Welcome everyone to this Privacy Rules webinar. Today we are going to discuss about the so-called thin line between personal and non-personal data. And we are going to do that with a panel of experts that comes from different corners of the world. A first few words, I would like to particularly thank Stephen and Parminder for being here with us today. We know that in India is a particularly difficult situation, and we really appreciated their participation also in this context. So thank you very much to you both in particular for being with us today. I would also like to thank our guest speaker, Michèle Finck, for being with us and giving her availability to join us today. And all our members, our law experts, so Stephen, Michael, Jean-Christophe, and Sergey, that will also provide the law perspective and their experience on this topic that is pretty complex. In many cases, the distinction between personal and non-personal data may seem to be something easy to recognize, but actually we understood that is not, and probably today we will see what are the risks related to this, and also how a non-personal data may become a personal data or be considered as a personal data in a different jurisdiction and in a different context. The moderator of the discussion of today is our expert from India, Stephen Mathias, and I would like to turn it over to you, Stephen. Stephen is expert from Kochhar law firm in India, and is a technology expert in particular, one of the leading ones. So Stephen, I turn it over to you, thanking you and all our panelists, and of course also thanking our attendees for joining us today.
Thank you, Alessandro. Welcome everyone to this discussion on the thin line between personal and non-personal data. Up to now, most of the regulation in the data privacy space has focused on personal data, but now we're seeing a new trend of looking at non-personal data and regulating that as well. My country, India, has been somewhat path-breaking in issuing a report on the subject, and we're very pleased to have Parminder Singh, who is a member of the committee who produced that report. We have an excellent panel from around the world who is going to discuss this subject, and I will just introduce each of them to you. I'll start with Michèle Finck, who's a senior research fellow at the Max Planck Institute for Innovation and Competition in Munich, Germany. She's also visiting professor at Lewis University in Rome. Her research focuses mostly on artificial intelligence in the digital economy, with a particular emphasis on data protection law. More recently, she's become interested in the intersection between digitization and sustainability. Our next panelist for this session, Parminder Singh, is the Executive Director of IT for Change and is based in Bangalore, India, same place where I come from. His areas of work are ICTs for development, internet governance, e-governance, and digital economy. He's been a special advisor to the United Nations Internet Governance Forum and the United Nations Global Alliance for ICTD. He was a member of the committee of the Government of India that issued the report on regulation of non-personal data. Next, we have Jean-Christophe Chevalier, who is a partner in the digital economy and data practice of Ydès. That's our member firm from France, and is involved in all the legal issues related to the digital economy, particularly the areas of intellectual property, literary and artistic property rights, IT law, networks, e-commerce, and so on. Next, we have Michael Nitardy, who is a partner in the US law firm Frost Brown Todd, and he's based in Florence, Kentucky in the US. He chairs the firm's privacy and data security team. He advises clients on how to deal with all aspects of the modern information economy. Michael helps clients comply with applicable laws governing the proper use and disclosure of personal information. In addition, he assists clients in investigating, addressing potential data breaches. And finally, we have Sergey Medvedev, who is a partner in the law firm of Gorodissky and Partners, and is based in Moscow, Russia. He heads the firm's intellectual property practice. His practice covers data protection, domain name disputes, franchising, cyberspace regulation, and e-commerce, apart from his core practice area, which is trademarks and designs. So a fantastic team from around the world. We have Germany, India, France, the US, and Russia. Let's kick off this discussion with the most basic question of all. What does non-personal data mean? It mean different things in different countries, and it has different aspects to it. I'd like to ask Jean-Christophe to kick off the discussion on this.
Hello, everyone, and thank you for joining us for this very interesting webinar. Just to reply to Stephen's questions, as part of European regulation, we have a regulation that is dated from November 2018, and that was applicable in May 2019. This EU regulation has set out a framework for the free flow of non-personal data in the EU. It also provides several examples of non-personal data. But it defined it by contrast to personal data, meaning that non-personal data is not a personal data. When we have given this answer, we did not give the real meaning of non-personal data. It is therefore logical that we instinctively look to the scope of the GDPR to determine what type of data shall be considered as a non-personal data. We can find it that would be an information that is anonymous, otherwise that is made anonymous, namely any information that does not relate to any identified or identifiable natural person. Therefore, the definition of personal data has been interpreted broadly as both the identification of the data subject, but also the consequence of the data on the individual has to be considered when looking for personal data. That really means that therefore we have to ask to the European Commission what does really mean as a non-personal data. And for the European Commission, it divides non-personal data in two categories depending on its origin. That means that non-personal data can be either data that initially did not relate to an identified or an identifiable natural person, such as data relating to the weather conditions generated by sensors installed on wind turbines, or data that was originally personal data that was later on anonymized. Clearly, the guidelines set out by the EU regulation still draw from the opposition between personal and non-personal data. However, there is one thing which is certain, that knowing clearly what non-personal data really mean will only lead to legal uncertainty. Thank you.
Wow, that's a dire warning. Sergey, what's the Russian perspective on this?
Well, in Russia we have law that covers protection of personal data, and Russia doesn't adhere to GDPR. That's why we have our own regulation that needs to be mentioned that covers personal data. Personal data is any information that can directly or indirectly identify a person. So, which means that personal data is something that describes something or defines a person. There is no special definition or concept of non-personal data in this particular law. That is why in practice we basically speak about non-personal data when it is not possible to identify a person. For example, it can be a cell phone, a phone number, which doesn't necessarily relate to a person when you call him, for example. An email, for example, without any additional information, without name, surname, address, to which you need to deliver your product from an online platform, for example. So basically, some bit of information which doesn't necessarily define or let the other person identify the person in connection with which the data has been provided. On a separate note, we have a special regime that protects certain pieces of information of any kind, including technical information, including organizational, including financial and other assets of the company, because information is an asset as well as intellectual property, for example. In this context, I mean trade secret. So trade secret can relate to non-personal information, because the information that trade secrets protects is know-how, which doesn't necessarily relate to something personal. So that's the Russian approach.
Thank you, Sergey. Mike, the US has had somewhat of a soft touch approach to data privacy, right? And it's mostly regulated, I think, by the different states. So is there much coming out of the US on non-personal data?
That's a great question. And the answer is no. I think that the US right now is really where both Europe and Russia are, but we've gotten there by accident or by just not doing anything as it relates to personal data as a whole. There is no overarching federal law as it relates to personal data in the United States. That is a point of conflict for many privacy professionals, not just in the United States, but throughout the world. We do have, our largest state does have overarching privacy legislation, which is in California for the CCPA. And so that probably leads the discussion more than anything else in the United States right now, as it relates to personal data. And the reason why I start there is because we can't even agree on what personal data is as a nation. So it's kind of hard to agree on what non-personal data is. But from the standpoint of California, California is like the EU in a sense that personal data would be anything that can reasonably identify or relate to or describe an individual or a household. Actually, in California, it adds that. So then non-personal data would be just the opposite of that. It would be any type of data that does not reasonably identify, describe, or identify or relate to an individual or a household.
Okay. So I think by and large, we're seeing non-personal data is essentially of two types. The first one being data that doesn't identify an individual, so it's not personal in nature. And the second one is personal data that's anonymized and probably aggregated. So the personal element is removed from it. Let's take this forward and look more closely at the EU. And I'd like to ask Michèle, what's the relevance of the distinction between personal and non-personal data for data marketplaces? I understand there's a Data Governance Act in the EU.
Right. So let me provide some background by saying that the Data Governance Act is a proposed piece of legislation that was proposed by the European Commission last fall. And the objective of the Data Governance Act would be to further incentivize the sharing of both personal and non-personal data between different actors in the EU. So it forms part of the current European Union's data strategy. And I think what's really interesting about the data strategy is that essentially it seeks to further incentivize the sharing of data, and thus I would say marks a bit of a new chapter in the history of data law in the EU compared to earlier decades where the focus was really only on data protection law. And the way in which the Data Governance Act tries to do this is through the creation of a light touch notification framework for data sharing services. And the DGA uses this notion of data sharing services, but the synonyms would be data marketplaces or data exchanges, for instance. And because it's a light touch legal framework, it only really imposes very few legal obligations on such data marketplaces. But the most significant one is that they must ensure respect with the General Data Protection Regulation, where the data that they are intermediating is personal data. So in practice, this means that a data sharing service needs to be in a position to identify whether the data that they are intermediating is personal data or non-personal data. And if we look at the very broad definition of a data controller under the GDPR right now, the second conclusion is really that data marketplaces would also very likely qualify as data controllers and thus have to comply with the entire breadth of the GDPR in relation to any personal data that they might be intermediating. And so really the distinction between personal and non-personal data is crucial when we're talking about the future success and applicable legal framework in relation to data marketplaces. But up until now, I would say that the European Commission hasn't really addressed this issue heads on, right? So it's saying, yes, data marketplaces would need to comply with the GDPR, but there's lots and lots of open questions as to what this actually means in practice, particularly considering the fact that some marketplaces, they don't actually pool the data in one place. They just offer a technical infrastructure that facilitates others to share data. And particularly in those scenarios, it's very hard to see how the data marketplace itself could actually determine whether data is personal data or not and ensure respect with the GDPR. So I think going forward, as this proposed piece of legislation is further negotiated, it will be crucial to get more clarity on this and for data marketplaces, to get some concrete sort of guidance as to how they are to address this distinction between personal and non-personal data and how they could actually apply the GDPR in the course of their business model.
So, Michèle, do you see any specific obligation on anyone to share non-personal data under this proposed law?
No, the Data Governance Act itself doesn't have any such obligations, but everyone's very impatiently waiting for another piece of legislation to be proposed. It is assumed that this piece of legislation will be called the Data Act, and the rumor on the street is that this Data Act would create concrete rights to access data. I can't say at this stage whether it would only be non-personal data or also personal data beyond the sort of ways of accessing personal data enshrined in the GDPR itself. There's already sectorial legislation in the EU that does have some data sharing obligations in relation to chemicals or car maintenance and other very specific sectors. But most people are expecting that in the months to come, there's probably going to be a horizontal legal framework that will move this further.
Okay, thank you. So, Parminder, it looks like India has really taken the lead here with regard to a specific proposal on what to do with non-personal data. Could you tell us a little bit about the report that you were part of in terms of what non-personal data is covered, how should it be shared, and more importantly, what's the rationale for this approach?
Thanks, Stephen. I'd go there, but just carrying on with what Michèle was saying, that Data Governance Act in EU sets up an enabling framework, and the Data Act would probably give rights. But the Digital Markets Act also has a mandatory sharing provision regarding search engine data, which is considered one of the more bigger digital monopolies. From where I will take the rationale of what you talk to me as a southern country, as a developing country, there is a feeling that there is a data colonization, that data is taken out of our countries, changed into intelligent products, which services are then sold back to us. And if we have to survive in this bipolar China-US-based data world, then we need to figure out ways to conserve our data and develop certain services and a digital industry on the top of it. If you ask me, that's the rationale. There could be many other theoretical, philosophical bases which I would discuss, and we have done it in the committee. But the real rationale why the committee was constituted and why they worked was this. Now, what do they do, and what is the data which needs to be shared? That's a very interesting distinction they make. EU did between NPD, which is taken from inanimate objects, or non-living, non-human beings, and those which were earlier PD. That distinction also holds. But here, there is a new distinction about NPD, which could be considered as belonging to people or a community, and NPD, which can be considered private. So one side is a community NPD and other side is a private NPD. The earlier versions had these names, community NPD and private NPD. In the latest version, and a new one will be produced by soon, we did not use these words because we did not want to create a new private rights by saying private NPD, and therefore we also took away the community NPD. But in essence, that meaning is everywhere in the report. It says that what is the data that a community has rights over, and it says data which pertains to a community and or is generated by it and or has its sources in the community. And at one point, it gives exception to data sharing much later, which says that the company does not have to share data if it is a trade secret, sensitive business information, or other proprietary information related to its internal processes. So in a way, there are two kinds of NPD. One which you pick up from people, from public places, from the climate, agriculture, land. We have picked it out from outside. That's one kind of data. And the data which is produced from within an organization. You have an AI engine playing chess with another AI engine, which is producing a lot of data. You're doing an experiment inside an organization. Everything is NPD. So it's created this line between community data and private data. It doesn't use those words, as I said, but these definitions are there. And having separated this line, and I think this is the biggest conceptual work the committee does, it therefore says that the community data is something on which the community has a right. It could be in New Delhi, the commuters of New Delhi has a right over transportation data, farmers in a district have rights over the agriculture data, and so on. And as a country, there is a community right to India's data. And then it goes and says which data should be shared. And in this also, there's an evolution. Earlier, it was said that all community data should be shared. There were a lot of problems that it will create chaos and so on. Now, beautifully, towards the end, a process has been developed that an authority would, along with a community trustee, recognize some data as high-value data sets, which are supposed to be essential to a sector, or they're essential to a public purpose, like disaster management, or making education policy, or making an education program, but also, for example, to start a digital taxi company. So that data, which is considered essential, would be nominated as high-value data set in one particular sector. You may only start with health, and then later on go to transportation. It's been done in a rolling manner. Any data which is community data has been denominated as high-value data set with the assent of the non-personal data authority to be set up, would then need to be shared. And what has to be shared is only raw data and not inferred data on which the company has rights. How the data sharing has to be done, we have asked for not a direct business-to-business data sharing, but the sharing has to be done to a centralized community data trust, which would be a semi-public body. And therefore, all the protocols of safety, protection, etc., are then the responsibility of this body and not the original sharer. And the rationale, I can come back again, but the real rationale is digital industrialization. Theoretical rationales are, we have a well-developed community rights in discussion in the report, which takes from natural resources rights, from traditional knowledge rights, flora and fauna rights in the Convention for Biological Diversity. So we do it from many rights places, these kind of rights, and develop community rights over data. But essentially, it's a matter of economic self-determination. Thank you.
Okay. It sounds a lot scary than when you first look at it. It seems to be more focused on public good. So it doesn't really deal with, say, someone going to Amazon and saying this particular group of people, I want to know this particular type of people. I want to know what kind of products are they interested in buying or something like that, which is more commercial. Would you say that?
It could be. See, there is a public purpose, but competition in a sector could also be that kind of a public person. So the purpose has been constrained, but it does not exclude economic purposes. But this determination, and therefore nobody would be allowed to ask Amazon its own internal product strategy, etc. But there could be fundamental things about a sector which are considered infrastructural. And I must tell that this is a pioneering document on which many jurisprudential and theoretical developments would take place, but we did choose to start a point of departure. And all the kind of questions you are asking are really scary. But the last point, it's like first the land was parceled as private property. Before that, it was not a private property. And then it took decades and decades to develop, and it is still developing the means of ownership around it. Similarly, later on, industrial owner, financial ownership, and recently intellectual property ownership. So the point of departure we have set out, but then there's many a nuance to be added over it to protect all stakeholders' interests. We are not looking for a data socialism, but we also do not want a free-for-all data systems where the collector of data takes away all value of that data. This is not found sustainable all over the world. And the real point there is collector versus from where it is collected. And we have to allocate rights in some kind of a balanced manner.
Thank you, Parminder. Mike, any thoughts on other global standards relating to non-personal data?
That's a great question. I'm not aware of any at this time. I think it's clear that India is really leading on this. It's great to hear from Parminder about the reasoning and some of the logic behind what is taking place. It's really, and I think at the very beginning he mentioned that it was between the two, the poles of China and the U.S. That the rest of the world has to do something. So it's very, very interesting to hear about. But as far as other attempts to regulate in this area, or any standards, I'm not aware of any, and so I think that this is very future forward looking by India and others that would be interested in moving forward in this space.
Right. Jean-Christophe, your thoughts on this? You're on mute.
Sorry. Actually, this is almost the same, I think, in France or eventually in Europe, because we don't have any. I don't really see any global standard that we could have for non-personal data. In addition to the EU regulation that we have today, and but sometimes we can take, if we want to protect such type of data, we have to go deeper in the category of data that we can have, and how did we raise this type of data, and then maybe try to protect it under the let's say IP law regulation, otherwise even eventually also on trade secrets and know-how, as Sergey mentioned before. We talk about this later, but when we have to discuss and negotiate some contracts where there are some non-personal data, we usually try to cover the risks in this by a very straightforward and consensual confidentiality agreement, and make sure that we all the parties will consider that like mostly like sensitive data, but not personal data. Meaning.
Thanks, Sergey. Is there a Russian perspective on this?
Thanks a lot for giving me a word. So I would agree with Jean-Christophe that since there are no European global standard and Russia is not an exception here, I would rely on other legal tools and technical tools, by the way, to protect such pieces of information, including from the standpoint of confidentiality and non-disclosure agreements. If we share this information with a partner, for example, on the IT side, maybe we can recommend the business to turn to encryption systems or methods when certain pieces of information, non-personal information, can be decoded. Again, I was talking about trade secrets from the IP perspective, since certain pieces of non-personal information can present a great value since it is not known to third parties. So I would also rely on IP protection, and in Russia we have a special trade secrets regime. I can talk about it later. So depending on a situation, there might be a standard, but there is no unified or global, I would say, unified standard that we can rely in Russia.
Okay. Parminder, I'd like to come back to you in terms of, what are the issues around ownership of or access to and sharing of NPD, I mean, more generically rather than just, focused on India?
I think ownership, as we have seen till now, it was generally from the issue of invasion of privacy. It was a human rights issue. And that has been well dealt with. It needs more dealing. India is doing it. Everybody is doing it. But increasingly, it was realized that in this age, data is the central resource, as was IP a little earlier, industrial and financial resources earlier, and land before that. And when something is a main resource, there's no question that it can go without an economic governance about it. There has to be an economic governance about it. There could be different schools of economic governance. Some would be more private-oriented, others more collective-oriented. Some may take a mixed economy view, but there has to be economic governance because the default is whoever collects it takes it, and that doesn't work anymore. That's the basic point. And in that sense, there is an ownership. Now, the problem with ownership immediately comes that in case of land and even intellectual property, partly, you could have personal ownership. You could personally own a house and personally own even IP and all, and that worked. The problem with data is that a personal piece of data is actually not very valuable. It doesn't matter my dressing sense or my living sense has a very small value, but if it is put together with many people like me, it becomes a central asset of the economy. This is a fact of the economy. Again, this is a mathematical fact. This is not a perspective of view. So once that has been realized, now either we just leave it again, since we can't have an individual ownership of any meaningful kind. Monetization, individual monetization has been tried and it's been found to be stupendously stupid or foolish. You get a few dollars or something for all your Facebook data. It doesn't mean anything. So the only way the data has value has in collective. So what do? Either you just give it and says, then okay, whoever collects data takes it. But then the collectives have been losing out. And I've been talking about the China and US bipolar world. And Europe actually inside realizes that its situation is increasingly becoming like that of, I'm sorry to say, a developing country. It's like, just because you make good Mercedes cars, you cannot be successful digitally in the same way just because if you had good land like India had before colonization, you can't become an industrial giant. So just because you have manufacturing strength doesn't make you become a digital, you're just losing out there. So you have, and everybody, country and collectives have to take a decision how to take charge of this resource. And this is the ownership issue. The economic ownership first, because it is the biggest resource, and second is the nature of data that individual pieces of data don't have much value. I mean, the marginal value of individual pieces of data is near zero, but collective data value is the central value in this society. So that's the only way to have collective pieces. And that's where India came in. By the way, this month, South Africa also has come out with a data policy. And I just received it today. I did to read it. But I think it's much more statist than India's is. I have been involved also with the South Africans, but I think this policy is more statist. Now, India did something, I think, big. Between a state and a corporation, it invented partly the legal fiction of a community. Partly it's legal fiction, partly it's a fact. And therefore, it's diversified and democratized the controls over data in many ways. And if you really read the legal framework, many kinds of small groups have many rights. So it doesn't that the state takes it over, which was the big problem. And here we invented a community ownership, which is very diversified. A university could have become a data trustee of certain kinds of data. A non-profit could become some qualification. So we have tried to diversify throughout the society, but kept a public interest and community interest. So this is what the ownership means. The issue of access and sharing, and I'll quickly touch upon it. What are the issues around access? Now, access is a dual issue, and we realized also when we were doing this committee work that if you ask everybody to share data, it actually could benefit the biggest companies. Actually, the biggest company who are already the incumbent are the best situation to benefit from a lot of shared data. If you are setting up a new company and you want to go into restaurant, I mean, you are Amazon and you want to food delivery and you have everything else, you have even logistics, and you just need the data of restaurants, and through this data sharing frameworks, you get that data itself, and then bigger becomes bigger. So what happens about big versus small? And therefore, the framework does try to take stock of how those excess issues are solved. Excess should not become a reverse stream of greater, making more powerful the already powerful. Then also there is the excess issue of insider versus outsider. Can communities, like indigenous communities, we immediately agree that they have certain rights to keep something among themselves. But do states, regional areas, districts, some farmers of certain kind of fruits have a right to say that this data would be accessed internally in a preferential way rather than outside? And I'm again not going back to some earlier century kind of mercantilist notions. But we know that we today also, whether this was a pandemic and all, and the new digital industrial policy, even which the US is starting to do, there would be insider outsiders. Eleanor Ostrom is the biggest theorist of commons. And the first principle of Eleanor Ostrom's is the inside-outsider divide. So anyway, so these are the excess issues, big, small, inside, outside, and it has to be configured in many ways. And sharing-wise, the last point, there are two parts of the concerns around sharing. One is the sharing concerns related to whose data it is. A community has concerns that the data which it shares, and you people are rightly talking that the line could be thin between NPD and PD, or even if it remains NPD, it can cause harm. We have a wrong notion that only PD can cause harm. A data which is anonymized across, say, gay people in a city, their behavior in a city can be used to harm gay people. It can be used to harm minorities. In that sense, it can be used to harm certain consumer goods. So there is a harm even in NPD. So a community wants to share data in a manner and to the extent where its laws apply, or at least where they could be in a reciprocal arrangement with other laws. So the issue of how to share and where to share comes in, and there is certain localization issues or bilateral standards development issues and so on. And the last issue of the sharing, of course, is that if a private company is forced to share data, with whom is the liability if some damage takes place on a later point after the sharing has taken place? And this is the reason the Indian committee asked the sharing to take place with a community trust, which is then responsible completely, and the original company is rid of all kind of obligations about the data which is set shared. So these are the kinds of concerns which get kicked in with the kind of thing this committee was trying to tackle.
I'm struck by one thing which you said about the EU, that it has the manufacturing prowess, but perhaps not in the digital arena, and that it's probably this concept is not just a developing country concept, but could apply to the EU as well. I want to just move on to a new topic now. I want to talk about AI, and I'd like to understand the impact of AI on the distinction between personal and non-personal data. Michèle, could you lead us through that?
Yeah, sure, I'd be happy to. So from the EU perspective, the definition of personal data in the EU is obviously enshrined in the General Data Protection Regulation, which provides that any data that actually or potentially relates to an identified or identifiable natural person constitutes personal data. So we can already see from the text that this is a very broad definition, and it has been interpreted in an even broader way by relevant supervisory authorities as well as the courts, to the extent that as soon as you have a risk of data being able to identify a natural person, that will qualify as personal data and hence be subject to the GDPR. Now, what does this mean from an AI perspective? When we think about what AI does, is it essentially allows you to draw inferences from data, right? This is what particularly machine learning and deep learning are doing. They are allowing you to draw inferences from data that are not apparent from the data itself. And this inference can be the establishment of person relatedness. right? So you can use techniques such as machine learning or deep learning to infer information from data that on its face is non-personal data, but which would then make it personal data, right? So you could triangulate two pieces of non-personal data essentially, and the application of AI to those two pieces of non-personal data might result in personal data. And there's a really rich body of literature in computer science that has emerged over the past couple of years that proves this time and time again, that AI really does make it much easier to transform non-personal data into personal data and hence subjected to data protection law. So really, I think one of the things that we're going to see with AI from a data law perspective is that even more data than currently will be qualifying as personal data and hence be subjected to the application of data protection law.
So you're saying the parameters are such it's not sufficiently anonymized?
I don't know if
there's enough in that data for you to be able to make some form of identification.
Right. I think anonymization is a bit of a different issue because it presupposes that something was once qualified as personal data and is then technically modified so as to no longer constitute personal data. And of course, this is a technical development also relevant in the context of AI, which also broadens the scope of application of data protection law. But I think in addition to this, what we'll see through AI is that AI will allow you to match different pieces of non-personal data, which were never qualified as personal data in the past. And by drawing inferences from those different sources of non-personal data, produce personal data, if that makes sense. So I think it's a bit of a different issue than anonymization. What both issues have in common from an EU law perspective is that because of the very broad definition of the GDPR's material scope, both of those developments, both anonymization and the drawing of inferences through AI, really underline that a lot of data which you might maybe think of as being non-personal data from an EU, from a sort of intuitive perspective, ultimately qualify as personal data from a legal perspective.
So, you're saying there are some risks basically to using anonymized data?
Yes, definitely. I mean, it's not, again, I think the anonymization issue is distinct from the fact that AI allows you to draw inferences from different pieces of non-personal data. But yes, definitely, there are risks to using anonymized data in the context of AI, and I think they're mainly of two kinds. So first of all, a lot of the data that people might think as anonymous data actually would qualify as pseudonymous data under the GDPR. And that is a very important distinction because the GDPR does not apply to properly anonymized data, but it fully applies to pseudonymized data. So that's definitely one kind of risk. And the second kind of risk is precisely that you could take properly anonymized data and by analyzing it through one of the conventional AI techniques, such as machine or deep learning, it could be transformed into personal data due to the inferences that those techniques allow you to draw.
Mike, your thoughts on this risks of using anonymized data?
Yeah, I think that it's a very interesting topic, and I think that and Michèle kind of hit on some of the issues there. That as it relates to, I think that what we need to discuss is, are we talking about an original set of data that is definitely personal data that we can identify people, that we then take to try to de-identify, and we keep that set of identifiable information, but we want to work with this set of de-identified information. And as long as we keep this original set of identifiable information, there's going to be some type of link with our technology between the two, so that you're going to be able to somehow identify the second set. Okay, so the question is it truly, to be a truly anonymous, in my mind, the way I look at it is that you no longer have the identifiable first set. You know, there's no way to connect it back to anything. So as we become more and more technical and we have more ability and we have more data, it becomes much more difficult to ever truly not be able to tie information back to its original set. And so I think that's the problem, is that how do you ever really truly anonymize anything unless it was just anonymous from the very beginning? So that's one thing that California actually has, that it doesn't speak about anonymous data. It talks about de-identified data. And one of the things that de-identified data, that in order to make it de-identified is the organization that's in charge of it must make no attempt to re-identify it, and also must have safeguards in place so that it cannot attempt to re-identify it. And so I think that this is why this topic is extremely important, is because people will say or will call what they've done anonymization when it's really, as Michèle said, pseudonymization, or it's just not sufficiently anonymized to the standpoint that other technology can re-identify it anyways.
Okay, very interesting. I wanted to move on to a slightly different topic now. How does the distinction between personal and non-personal data influence the difference between trade secrets and know-how? What's the difference there? Sergey, could you lead the discussion here?
Yeah, sure. So as I mentioned at the beginning, in Russia, there is a special intellectual property subject matter, which is called know-how or secret of production. And from the name of this notion, it is crystal clear that this relates to some sort of information that is made from production. So, but if we refer to Article 1365 of the Russian Civil Code, we will see that know-how can be any information, including organizational, including business-oriented, including production-related, etc., which presents certain kind of value and which is not known to third parties. In respect of which, of course, the owner of such information has undertaken certain reasonable measures to protect its secrecy. So basically, know-how is, again, a piece of information that can be protected. And I want to emphasize again that this is not specifically non-personal data, but it's a way or manner how the information can be protected from the intellectual property perspective. And when we talk about reasonable measures, I'm sure the same regulation applies in EU. These reasonable measures are to be defined by the owner of such information. It can be, again, legal measures such as documents, policies, confidentiality agreements, as well as technical agreements, such as computer logs, such as I don't know, computer safes, some sorts of technical stuff that can prohibit a third party or the employee from stealing this particular information and from disclosing it to the public, because of course disclosure makes the protection of know-how impossible, and the exclusive rights to such know-how will lapse. In this sense, again, I shall emphasize that non-personal data can be subject to know-how if it can present a certain value, actual or potential, and of course, if it's not known to third party, and if certain reasonable measures have been undertaken. Trade secrets regime, which are 5 checklist points you have to do can be a reasonable measure. We have a special law called Trade Secrets Law, and there is a specific 5 points that the owner of information must undertake. That's make Russia unique from other jurisdictions, because as I know, there is no such law in Europe or US, but this law is just a layout of practice. You have to define the information, you have to prepare policies, agreements, you have to put trade secret on your tangible medium of expression, or the documents or emails that you share with third parties, and you have to undertake all these 5 measures as expressly written in this law. If one of them is missing, no trade secrets regime applies, and when you enforce your rights to trade secret, the court will dismiss the case, saying that no, one of that particular points was not complied. So in summary, know-how can be a good way of method of protection of non-personal information.
Okay. Jean-Christophe, do you have any thoughts on this?
Yes, which the thing is that it's very interesting to see that Russian law is almost very similar to the European regulation, and especially the French law, which is, to be frank, something that is helpful for all of us around the table, because we can have the same way of protection about know-how and trade secrets. So I will not rephrase exactly the same as Sergey mentioned, but I will just point out the fact that know-how is the value of the company. So when we should consider that when the company decides to collect several types of data, meaning non-personal data, such as economical data, statistic data, in order to retrieve and develop a project, then this should come into the scope of the know-how, and then we could consider, according to the European regulation, otherwise the French law, that should be protected as with an IP rights, or otherwise should be protected as a know-how of the company. And then we have exactly the same for trade secrets, and we will obviously try to protect this via confidentiality agreement, via non-disclosure agreement, via you can also put a deposit to a belief in order to make sure that your project, which is only an ID, but that arise from several meetings and several internal discussions, should be protected as confidential and as being part of the know-how of the company. So there are several ways to protect it under IP law. And when I see the regulation about non-personal data that set out, let's say, a freedom of sharing about this kind of data, the fact that we have regulation on trade secrets and know-how to protect, to give us some way and means to make sure that these data flows can be protected, either in order to ensure that the asset of any companies and actors are well protected, then I see that we will have let's say a lot of opportunities for companies to make sure that their know-how and trade secret is well protected.
Okay. We've come to the we finished most of our discussion for today. I'd like, before we move on to Q&A, I'd like each of speakers to just spend a very short, maybe a minute, and just give what they think is the one key takeaway to get from this discussion today. And I'll start with Parminder.
I think the key takeaway is that data is, first of all, a very original asset or thing of value, which has not been framed under any existing regime. IP protections is an attempt to cover. It could serve in between role, but that's not adequate and mostly does not apply. And I don't want to go into details. And therefore, we need a manner of measuring this value and apportioning this value. One, that's important. And second part of it, and when we apportion this value, the biggest thing is about between a data collector and whose data it is. And on the side of whose data it is, they are individuals, but they are also collectives. And as I said earlier, that individual ownership is very difficult in terms of data. So it's largely will be collective ownership. And these two cardinal points are recognized even partially. You start moving more or less towards the direction in which India is moving, as I understand. Thank you.
Okay, great. Michèle?
I would say that governing and regulating data is hard. I mean, it's something I kind of knew before, but I think today's discussion again brought this to the fore. And I think there's a number of reasons to that. Firstly, data is unique in that it is both something to which fundamental rights or human rights relate, but it's also an economic asset, and reconciling those two things is difficult. And then I think it's also important and maybe reassuring to remember that data or digital data particularly, which I think is what we are talking about here really, is new, right? It's something that has only emerged a few decades ago, and I think as humans and societies and legal systems, we still really need to learn how to deal with this, how to govern this, how to regulate this. If we think about other assets and things to which in which we have human rights, there's much more experience, there's a much longer learning period in which this was done. And with data, we're all just beginners at the very beginning of this data age, as you want to call it. So I think it's all experimentation, and I think it's important to sometimes acknowledge that we still need to learn how to do all of this, and there's probably no sort of bulletproof solutions, and also that we need to learn from another, both between disciplines and professions, but I think also between jurisdictions.
Okay, Sergey, your thoughts?
That's a very good question, and I would start first of all with a distinction between personal and non-personal data. When we work, when we receive, when we share the data, we must of course understand what is personal and what is non-personal, since the consequences and implication of treating the same are very different, as we talked today. Number two is, besides the distinction between these two notions, is the careful understanding of what is behind non-personal data that we are using, sharing, receiving, transferring, etc. If it's non-personal that doesn't identify the person, then we must understand what legal, organizational, or security measures we can take, as with personal data, to protect this data. Or maybe we can again apply IP mechanisms like trade secrets, which we talked a few minutes ago, to such kind of data. That's number two. Number three is anonymization. I didn't talk today about Russian law, but be careful, since in Russia anonymization is personal data, and Article 9.1 of the Federal Law on Personal Data clearly says that yes, anonymization is personal data. So all implications which refer to data protection and regulations in law, which applies to regular personal data, applies to that. And from the business perspective, the supervisory authority says that upon achieving the purpose for which the data was collected, you have to destroy it. Anonymization is not a solution for companies and businesses. It only can apply to state and municipal authorities in Russia, as again supervisory authority emphasizes. So again, be careful with anonymization. And number four, I would just say enforce your rights, since understanding the distinction, understanding what is behind, we have to enforce our rights in case there is a breach, in case there is a claim or something. We must understand, since we are lawyers, where to go, how to enforce, what we can achieve, a fine, or blockage, since a lot of websites, even in Russia, are blocked because there is a data breach. So the same can apply to non-personal data breach. So we need to be careful and carefully enforce our rights in this particular area.
Thanks. Mike, one key takeaway.
Yeah, I think just very briefly that this just underscores the growing importance of all data, whether personal or non-personal data, to our world today. And I think that it's a very interesting topic, and it just underscores the importance of privacy rules and the work that we're doing.
Okay. Jean-Christophe, the floor is yours for the last word.
Thank you. Yeah, I will try to be as quick as possible. And I would say that it's always good to have a regulation applicable to any kind of topic, such as non-personal data and personal data. And this distinction is quite also very important, because this also allows us as lawyers to be able to determine and advise as best as possible our client in the way to protect the different category of data that they collect and that they share with their partners and so on. And it's also something that is useful to have, because when we are talking about data transfer, if there is a personal data, then this is a mess from EU to all around to the rest of the world. But when we talk about non-personal data, this should not be a big mess as before. And that the question is different and almost the same for us as for Sergey. If we talk about anonymized data or pseudonymized data, anyway. So, but this is another topic that we could talk about later if you want.
Okay, so we have a bunch of questions from the participants here, and I'm going to run through a few of them. I'll start with this one. Some companies interpret and consider that data is anonymized in a very liberal manner, which enable them to use such information without the burden of privacy compliance. Can you provide your views on how to consider data as sufficiently anonymized, and how to advise companies with the right criteria to consider it to not fall under privacy laws in your jurisdiction? Who'd like to take that up?
I'm happy to speak to this from the EU perspective. So
sure, Michèle.
In the EU, as I previously mentioned, the definition of personal data is extremely broad, and that implies that definitely lots of the data that people think of as anonymized isn't anonymized from a legal perspective. And there's a bit of an ongoing debate as to how this notion of the distinction between personal and non-personal, thus anonymized data, is to be interpreted from an EU context. But at least the predominant school of thought would say that as long as there is a risk of identification, then you ought to treat the data as being personal data. And of course, the assessment of this risk is contextual. And I think the sort of contextual nature of the definition of personal data is one of the factors that make this area of the law really, really hard, right? And that also something that increases, or with increasing technical means of, for instance, reverse engineering, pseudonymization or anonymization processes. And so coming back to sort of the importance of AI in this context, I think that going forward, there will be scenarios in which it will be even harder to claim that personal data has been successfully anonymized, because you could use a given machine learning algorithm to reverse engineer the sort of anonymization that has been done.
Thanks. I think a lot of the questions actually seem to be focused on anonymization. So here's another one. Given Shrem's AI, etc., and difficulties to navigate globally with the sharing of personal data, are you aware of any technology that can de-identify data relative anonymization and avoid privacy compliance? Do you think solution could be technical rather than legal? I know we have a panel mostly of lawyers here, so and anyone here able to take that? Parminder, how about you?
No, I'm not a technician either, and I don't know what exactly it means that. I think, as Michèle said and others said, there would be possibilities, and we will have to remain in the realm of best effort. There, as the Indian law says, that there will be standards defined, and I'm sure in EU there would be some standards which are common, defined, that this constitutes anonymization, and everybody knows that there is no real anonymization. So, but something has to constitute anonymization, and it is a fact that all companies today, their major wealth comes out of anonymized data. All AI works on anonymized data. So they are doing it all the time. They are already taking the risk. So the point is that the intent will be in question. Law is not a technology. Law goes by intent. The companies have to show best intent and not a lack of due care. And by the way, this is a small thing from the committee's report. What the committee does is that right now the non-personal data is under no legal framework. So either it is personal data, which is under legal framework, or you can keep on extending the definition of personal data, but at one point it is non-personal data, and then it is definitionally out of all legal frameworks. But this committee said that even NPD under you have a duty of care, and how the duty of care and fiduciary responsibility will be defined is going to be a growing jurisdiction. But that new framework has been put on NPD. It's not at all going to answering the question your questioner asked. But to me, then a lot of legal intersection with technology will come. You will be judged for your intentions and best effort. And increasingly, there will be a criminalization of a deliberate mischief or a criminal negligence. These areas will evolve, I understand.
Okay. So I'm going to take up a part of one of the questions that's been asked, which relates to competition. I'm going to relate that to what Parminder mentioned, which is the Indian report does also talk about it in context of competition. Put in a more simple and kind of scary way, you have a big company that's collected a lot of data. You could have a scenario where the small company can say, I'm entitled to that data, and you need to share it with me. How does that how does that sit with the panelists? Because this is outside the public good part, and this is more in the commercial space. It's more about competition. Is there any justification for this? Are there any contours we can set here? Mike, would you want to take that up? It's a kind of concept that's very alien to the US, I guess.
No, definitely. It is very, very alien. I mean, obviously, we believe in everybody taking their own data and making money off of it, however they can try to do that. So it's an interesting concept that I think is, from my perspective, trying to, as Parminder said, trying to address the bipolar China-US dynamic of monetizing data already. It's going to be interesting to see how that develops, but I'm not certain that the concept would fly right now in the United States.
Jean-Christophe, do you have any thoughts on that?
No, no.
Sergey?
Well, that's a good question again. In Russia, the competition law is a bit separated from the laws devoted to information and even intellectual property law. These are kind of different blocks, and there is no case law or a precedent where competition law were touched, but there are some software-related cases where Federal Anti-Monopoly Service and its divisions would attack some American companies, maybe because of the geopolitical situation, maybe because of promoting Russian technologies, for example, on pre-installed software, for example, on selling and installing special apps when you sell your phones, but nothing specific to the subject matter we discussed today, to non-personal, more about the software and personal data.
Okay, so I had one key takeaway, which is, I find the whole concept of regulation of non-personal data to be very interesting, but I think it's very much at a nascent stage. And what I really recommend is that data protection authorities be empowered with the right to regulate non-personal data in the future and to go about this very, very slowly. The common good idea, which Parminder talked about, I think that's a very interesting concept, and clearly in some areas like data about weather, for instance, clearly there's a social benefit from that. But regulation of personal data has been around for a couple of decades or so, and it's been really tough, determining the contours of the law and how data is being regulated and so on. Non-personal data could be even harder. So my suggestion, particularly for the Indian legislation, is include the right with the authority and develop this concept slowly, as other countries will also do so. So with that, we've come to the end of our discussion today. I hope we got through most of the questions. I think most of the questions related to data anonymization, and as a result, we covered them directly or indirectly. So I'd like to thank all the panelists for a wonderful session today, and thank you, PrivacyRules, for giving us the platform to have this discussion. And I think over to Alessandro for the final word.
Thank you very much, Steve, and indeed a very insightful discussion. And you start thinking that something is complex, and then you understand that it's even more complex, and that was my final takeaway today. But extremely interesting to see how the same topic can interact in different sectors and in different situations, and also the bunch of questions we received was opening many other doors related to this. So definitely something that would require like days of webinars to be addressed, probably in all its aspects, and hopefully we will be able to go a bit deeper on this topic with future events. But for this one, I really thank all our speakers for being with us today, for their very relevant perspective. It has been extremely interesting to listen to you all. I would like also to thank our listeners for staying with us all the length of this webinar that was also pretty long but very interesting. So thank you all, and stay posted with PrivacyRules. We will also release the recording of this session so that everyone can go back and see if there was something missing, and they can send us other questions that we will certainly use for our next event. So thank you very much again, and I wish you all a very good day. Of course, our thoughts in particular to our Indian friends. We really hope that things will get better soon there. So our thoughts from, I think, PrivacyRules, but the entire community goes to you all, in particular, Stephen and Parminder. Thank you for finding time for being with us today, considering all the thing that is happening there. Thanks again, and bye, everyone.
Thank you.
Thank you.
Bye-bye.
Bye.
Bye.